So we're seeing all these strikes. Some of them are legal, some of them aren't. Why should employees want to engage in strikes and ensure that they're protected?
Peter, firstly, it's been a tough week. Condolences to the Mbuli family and the Money Life team. Employees would normally engage in a strike because of a deadlock over wage increase and negotiations.
All right, so what about the legality of thereof? What will happen if they don't? Why should they have a protected strike?
For the employees to have a protected strike, they must simply comply with the procedural requirements set out in Chapter 4 of the Labour Relations Act, and in particular Section 64 dealing with strikes and lockouts. And for that strike to be protected, all they need to do is to refer the issue over which is strikeable. In other words, the issue in dispute must be the one that the employees can engage in a strike. They must have a certificate from the CCMA or bargaining council, or 30 days.
So go through the procedures, get permission. What about the employer? What rights does he have during a strike?
The employer, during that a protected strike, he has the right to lock out the employees, or he can also apply for an interdict in the event that the strike gets out of control, there's misconduct, there's violence. And also, the employer has the right to take disciplinary steps against employees who misconduct themselves during the protected strike. If
the strike is not protected, what rights does the employer have? So if it's a wildcat strike and people just don't show up to work and they start striking?
With regards to a wildcat strike, the employer is still expected to act in a procedurally fair manner. For instance, issuing ultimatums, calling upon the trade union to intervene, giving notice to the striking employees, to cease their participation in the illegal strike, and also requiring those employees to attend a disciplinary inquiry, at which they will explain why they participate in the illegal strike and to give reasons why they should not be dismissed.
So they can't just fire willy-nilly, sort of mass dismissals?
There are limited circumstances, for instance, where there's turmoil, there's loss of life, damage to property. But even under those circumstances, at least the employer must meet the bare minimum of
having tried his best.
Best to call in trade union to intervene.
What about employees, who might not be part of a union or who want to work and are forced to stay away for their own safety? Are there any consequences for them in terms of legal action for not showing up to work?
There are consequences, but what is clear is that those employees may not necessarily be dismissed. However, the onus rests on them to prove that they were intimidated or forced to join the strike.
All right, so perhaps finally, what are the most common misconceptions that employees and employers alike have when it comes to strikes, and what they should really be careful of this season?
Peter, the biggest misconception, or should I say misgiving about strikes, is that they are no longer seen as better mechanism to resolve a deadlock, but instead they are seen as escalating the tensions between employees and the companies that they work for. And to restore that relationship will take a further amount of hard work and further trust between the parties, because one needs to move away from the us against them syndrome in the workplace. So that's essentially the misgiving about strikes, whether indeed they are a better mechanism to resolve a deadlock and or to force employers to agree to the wage demands that employees put across on the table.
All right, Osborne, we're going to have to leave it there, unfortunately, but certainly I think as we get into these deadlocks, follow the law, follow the procedures, and be fair at all times. Thank you very much indeed for your time, sir.
My pleasure.
All right. Okay, so that was Osborne Molatudi, who's a labour lawyer, telling us about the legalities of the strikes we're going to see.